Ladies and gentlemen, Miss Erin Jacobson. And they love you already. How are you, Erin?
I'm good. How are you?
I'm good, thank you. Great to see you.
You too.
We were just chuckling. Erin's got a neighbor walking a yappy dog outside. I've got construction going on, and both of my neighbors on each side are doing construction. So we may have some company, unwanted company, but it looks like we've got a very full chat room. Wow. Lots of people in the chat. Very excited to have you. Well, you know so many taxi members from doing a lot of road rallies and stuff, and obviously they all love you, and I know that many of them use you as their attorney. And so before our format today is Erin's got a class that she does at the road rally, and I really just want her to do the class. I will probably only dip in if there's something that I need to make an additional point, like, oh, taxi members should also know blah, blah, blah. But I doubt that I'll be doing much of that. And then after she does her thing, we'll open up the floor to some questions. Let's try to not make them really general, like, can you tell me what a good contract is? Because we couldn't do that in a minute or two to answer the questions. But, make them more specific. Anyway, before I hand the mic over to Erin, she's a practicing attorney, an experienced deal negotiator as opposed to an inexperienced one. That would be bad.
That would be bad.
A seasoned advisor of intellectual property rights who protects musicians, songwriters, music publishers, and a wide variety of other music professionals. Her clients include Grammy and Emmy Award winners, legacy artists and their catalogs, heirs and their estates, and independent artists and companies. She regularly handles all types of agreements within the music industry with an emphasis on music publishing and licensing. In addition to being named, this is a big deal, a Super Lawyers Rising Star and one of the top women attorneys in Southern California, Ms. Jacobson, says the bio, we know her as Erin, is a frequent author and speaker, has been featured in publications including Billboard and Forbes. She also serves on the board of directors of the Association of Independent Music Publishers. For more information, you can check her out at themusicindustrylawyer.com. That, once again, is themusicindustrylawyer.com. She's also one of only 2 attorneys that I consider a good friend, and she's an attorney that I actually use on a regular basis, so that may tell you something. The information she's going to share with you today is not legal advice. Think of it as entertainment that will help you protect yourself from getting screwed. Ladies and gentlemen, I give you Miss Erin Jacobson. Okay.
Thank you, Michael. I'll add, I think I didn't send you my updated bio. I have an additional thing on there, which is not the thing, not the thing that you were going to say. But I also was got named by Billboard as one of the top music lawyers on their list that came out this year.
Wow, nice.
Yeah, so that was exciting.
Did they send you like a Billboard cover in a frame, with your picture inserted?
No. I do have the magazine, but no, it didn't come in a frame and everything. So,
do you have any other news you'd like to share?
I do have some news to share. So I wrote a book. And so today is the announcement of the book day of the book. And we wanted to make it special because I know that this is something that, taxi members would be particularly interested in and really showed me the need for it because through a lot of our questions and whatnot. So the book is the same title as our class today, Don't Get Screwed, How to Protect Yourself as an Independent Musician. And it covers what copyright means and why you should register, the different types of royalties, how they apply in the real world, so you understand actually how and when your music is earning money, how to get paid the royalties that your music earns, the contracts most needed by independent musicians and why they're important to have, traps to avoid, and also a lot of real examples. of mistakes that musicians have made and how you can avoid making them too. And we'll go over some of this in the class today. But because we only have an hour, we're going to do a shortened version because normally at the road rally, I end up spending a lot of extra time after class answering questions, and we don't have that time today because we're on the web. But I want to make sure everybody gets a chance to answer their questions. So the book it'll be an ebook and print. It's currently available for pre-order with some bonus items if you sign up for the pre-order, and then the official release will be quite soon, and we'll update you with the actual date. I'm hearing an echo, Michael. Are you, or are we okay?
You know what? Maybe you should grab your headphones and plug them
Okay.
in. That should eliminate that.
Okay, let me grab those.
Meanwhile, while Erin's gone, let's have a tour of Erin's house.
Let's not. Okay. Got my little headphones here. One moment.
Yeah, I've never worn earbuds for as many hours as I have been this week. They really mess with your
Don't your
ears.
ears hurt?
Huh?
Okay, wait. Can you hear me?
Yep.
Okay. All right. Yeah, I normally don't wear them either, so. Oops. And then they fall out.
Probably in the wrong ears.
Okay.
I put a red dot on one of mine so I could tell right from left, and the dot rubbed off on my ear. Now I've got a red Sharpie thing on my ear.
The joys of technology.
Yeah, Edmund, I think Erin just talked about that. You can pre-order the book now?
Yeah, you can pre-order the book. So the way that we're doing it is you go to indieartistresource.com, you commit to the pre-order, and then we send you the link to Amazon and Barnes & Noble as soon as it's live there. You purchase it there, send in your proof of purchase, and then we send you your pre-order bonus freebies, which are the ultimate royalty chart and a catalog spreadsheet template, which are both really, really useful.
Nice.
So.
And also, I'm going to feature the book as one of our cool stuff items in the TAXI newsletter, in the December newsletter. Excuse me, I just burped in Erin's face. I'm so sorry.
Okay.
Anyway, I'll feature it in the December newsletter too, as a little reminder. So if you guys want to, like tell your spouse or some family members, hey, here's a great stocking stuffer in time for the holidays, we'll give you a hand.
Yeah.
So,
and it'll be like perfect stocking size too, because it'll be small.
Oh, great. Bria just posted the link to Indie
great.
Artist Resource. So
Thank
there
you.
you go. All right. So go ahead and launch into your thing, and I'm looking forward to
All
it. I'm sure
right.
the people in the chat room are as well.
Yeah. So, all right. So just a reminder, as Michael said, nothing's legal advice, entertainment purposes. And so, all right. So what I normally like to start with when just going over music rights is an important concept that is sometimes overlooked, and that is the separation of the musical composition and the master recording. Now, the composition is like music, lyrics, melody, like the stuff that TAXI members are composing. The recording of that is actually a separate entity. So anybody can do a recording, right? So you have, like, here's an example that I feel like has been getting a lot of attention lately. So the song I Will Always Love You, which was made famous or recorded by Whitney Houston and the Bodyguard and was like a huge hit. Michael, you're going with your notes. Because I see you big on my screen.
Sorry.
No, that's okay. So just out of curiosity, how many people know who actually wrote I Will Always Love You? I can't see the chat, Michael. You have to help.
Okay, it's good. There's a little bit of delay.
Yeah.
Spring level got it just right. Dolly Parton.
Yep. Right. So, I mean, but a lot of people don't know that. They just think of Whitney Houston when they hear that song. But so Dolly wrote the composition, but she also recorded it because it was her own song. So that's a master recording. Um, Whitney Houston's version that so many people know is also another master recording owned by another record label. So, why this is important is that the composition and the master recording, they each have their own copyrights, their own protections, and their own royalty streams. So, it becomes an issue, for example, contracts, which I draft every day, is very important for me to identify which asset, really, which is because it's intellectual property, which one of those is actually the subject of the contract, or maybe both of them are subject to the contract, depending on what kind of contract it is. But you need to know that because that affects how things are used, who can use them, how you're getting paid, what royalties are being collected. So it's always important to remember that there's that distinction between the composition and the master. So, and Michael, you can like jump in at any time if you feel like you want to.
Well, I don't want to suck your time, but I have to tell everybody that when I was like 20 years old, I was working on an Eric Clapton project, and he said, "Come on, let's go find the best chili dog in Miami." So we went out eating chili dogs. He took me to a record store and bought me the Dolly Parton album with "I Will Always Love You" on it, and handed me the LP and said, "She's going to be a big star." And when we walked up to the counter, the kid working behind the counter goes, "You're Eric Clapton." It was an awesome moment. There's my only contribution.
No,
please
that's
continue.
A great story. That's a great story. No, this is like when we do our taxi interviews, when we're at the office together and stuff, it's, I like our back and forth. So
yep. Free flowing, baby.
You're fine. So all right, so I want to talk just briefly about copyright because that's also really important. So having a copyright means that you have the ownership of a certain work, and work is actually technically copyrighted under the law when it's created and when it's put into a physical form, like recorded, written down, something that's physical that can be reproduced. It technically has copyright protection. However, it doesn't have the full benefit of what copyright law allows unless that work is registered with the United States Copyright Office. So that's when people talk about registering their copyrights and filing these applications with the US Copyright Office. That's what will give extra benefits to the ownership of the work. So some of those benefits are being able to sue in federal court if there's an infringement on the copyright, a public notice of who owns the work, listing in the Copyright Office's online database, saying like, here's this work and it was registered on this day and it registered by this person as the owner. So there's also that legal presumption of the ownership. And in an infringement suit, there's potentially statutory damages, which basically means money amounts that you can get set by the law. So it may mean that you can get more money if you win an infringement case. And also the date of creation that's listed on that federal registration that you submit with your application. That's the strongest evidence that a court will consider. So two of those benefits I really want to just emphasize again. One is that you cannot sue in federal court for copyright infringement without the registration with the U.S. Copyright Office. And two, the date of creation on that federal registration certificate is the strongest evidence that a court will consider. So, what that means is that doing things like mailing a copy to yourself is not sufficient evidence that you own the work or what date that it was created, and doesn't give you these protections that I just went over about what happens in an infringement situation if you need to assert your rights. Um, it means posting it on YouTube or the web or wherever. That does not count. And it also means that, other types of registrations are not going to be sufficient. So any sort of websites that offer date stamps or things like that, they're not going to offer the same protections that a federal registration with the Copyright Office is going to offer. And I think that that's an important point, because sometimes people want to cut corners on costs, especially for composers that are, have a lot of works to register, or maybe a lot of queues, which sometimes you can group applications depending on what it is, but not always. So that kind of depends. But it's one of those situations by like trying to save money by doing an unofficial registration that's at a cheaper price point than the Copyright Office is still not going to really give you any protection. And if you end up having an infringement issue, then it becomes a lot more expensive to then get a rush registration in order to be able to have the ability to sue in federal court.
And that's if your opponent in that case doesn't rush out and try and register it before, beat you to the courthouse steps as well.
Yeah, and it's possible that if you didn't register, maybe the other person or the other party had registered their work at the time that they created it. So now you're the one rushing to register your work, but they already have a pre-existing registration, which may hold some weight in their favor. So the copyright application fees, depending on what is filed and how it's filed, the fees are $45 to $65 per application. So again, we try and group things when we can, but it's not always possible. But it's best, if you're not sure how to file, then have an attorney assist with that that's experienced with filing copyright registrations, but also a lot of people file their own registrations too. So that is just a word about copyright.
In the old days, when you filed with the Copyright Office, people were under I believe, mistaken impression that they had to wait for the registration certificate to come back to them, which could sometimes take like 3 months, 6 months, 9 months. They were very slow.
Yeah, it's more like 6 to 9 months. Yeah.
Yeah. And nowadays it's all online. So would it hold up if I sent my registration today and got involved in a lawsuit? Would today's date, would they go back and say, well, look, he filed this on whatever date today is, November 4th?
Yeah. So the date is when you file the application. So you don't have to wait the 6 to 9 months to get your certificate for it to then be effective. But in a lawsuit situation, you would have to actually file for what they call special handling, which is rush processing, which is an extra $800. So save yourself $800 and don't wait until something happens to register.
Yeah.
So yeah, it gets complicated. So, all right. So quickly, because we're at 10:20 already. So I want to go over just a few different royalty collection services to make sure that people are signed up where they should be, so you can be collecting your royalties. So the first is a performance rights organization, which is, you've probably heard of them. ASCAP, BMI are the two most common ones. There's also CSAC and GMR, but GMR is like has private clients, so nobody's like just going and signing up on the website or anything. And CSAC is also by invitation only. So most people are going to be signing up with ASCAP or BMI because they're open to anyone who wants to join them.
And for Canadians who are watching, so can. I mean, obviously, every country's got its own,
every
PRO.
country has. So interestingly, in the U.S., they're not government affiliated companies, whereas in other countries, there's usually just like one sanctioned company for that country. But I don't know, for whatever way they worked it out in the US. So we have all these. So ASCAP and BMI are actually nonprofit organizations. And CSAC and GMR are just private companies. So, I mean, yeah, if you're in Canada, it's SOCAN. If you're in the UK, it's PRS. Every
APRA in
country has its
Australia,
own. Yeah, APRA in Australia, IMRO in Ireland, GEMA in Germany, SACEM in France. So, and they all have sort of reciprocal agreements as well. So, if you're American and you're living here in the US and you signed up with ASCAP, let's say, but then like the music's earning money in France, like SACEM will collect that money and then pay ASCAP, and then ASCAP will pay you, and vice versa. Like if you're French and you're registered with SACEM, but the music's earning money in the US, then ASCAP or BMI will collect it and then pay SACEM. And they're able to do all kinds of worldwide collection stuff. But what a performance rights organization actually does is they collect public performance royalties. So that is royalties when music is publicly performed. And I say that in quotes because that doesn't necessarily mean like someone is standing on a stage with an instrument performing live. A performance is anything that's available to the public or a substantial number of people that is just not somebody's friends and family. So that can be played on the radio, played on television, over the speakers in a restaurant, could be at a concert. So streaming is considered a performance. So there's a lot of different types of uses that are considered performance. And basically, if your music's out there, it's probably earning some performance money. And if you're not registered, then you're not collecting it. And the way that performance rights organizations divide up the money is they pay half to the writer and half to the publisher. So basically, if $1 of income comes in, 50 cents is going to the writer and 50 cents is going to the publisher. And so therefore, when you register with a performance rights organization, it's not just a one-step process. You have to register as a writer, and then if you are your own publisher and you're not signed to any publishing company or library, then you need to register as a publisher as well. So that way you're collecting both that writer share half and that publisher share half.
I've got a question relevant to that, which is, do you need to start a publishing company, like formally start one? People always kind of have that reflex to do that, and it's daunting to them. It's like, oh, I've got to file with the state and do all this stuff. Can you simply just put a DBA, doing business as, out there and call it, Michael Lasco Music Publishing, and send that into your PRO, and that's good enough to get the check?
Yeah, so the publishing company really is a DBA. It doesn't have to be, it can be a formal LLC or corporation or something like that if that makes sense for someone to do that, depending on where the person is in their career. But no, if you're maybe just starting out, the tax ramifications don't make sense, or maybe you can't afford to, form a corporation or an LLC, whatever it is. yeah, you can just file as a DBA, doing business as, also known as a fictitious business name. And then the publisher registration process, the way that works is, I mean, it's an online application similar to signing up as a writer, but you have to give like 3 to 5 potential names in order
Right.
of preference that you would want your publishing company to be called. And then they'll, like, the organization will do a name check because they want to make sure there's not anyone else that has that same name or has a name that's too similar that it would get confused. And then they'll let you know, like, your name, Michael Laskow Publishing, has been accepted, and then you'll be registered as a publisher and a writer.
I filed under
What?
Charles Manson Music Publishing, figuring nobody else would want that name.
And somebody else had it? Did
No,
Charles
I'm kidding.
Manson have it?
He probably did. He was a songwriter.
Yeah, no, I mean, I've actually heard of like an instance of like licensing his music for something. So that was interesting.
Yeah.
Not a case that I handled, but uh, a colleague actually like called me. He was like, I have a licensing question, has to do with this. I was like,
Oh my God.
okay. But anyway, so once you've registered as a writer and a publisher, again, if you're your own publisher, meaning you're not already signed with a third-party company, the other thing that you have to do is you have to register your individual compositions. So unlike copyright, where you actually have to pay an application fee for the individual work, when you're registering with a performance rights organization, you pay the application fee as a writer or a publisher, but then when you're registering the individual songs, that part is free. But the reason why you have to register the individual compositions is that otherwise they're not going to know what compositions belong to you or that you wrote, so they won't know to collect on those compositions, and they won't know to pay you, even if they know, okay, ABC Love Song has been performed on the radio, just as an example. But if they don't know who wrote that song or who publishes that song, they'll go, well, okay, we don't know who to pay. So that's why all the individual compositions have to be registered. And again, I know that especially for people that are writing a lot of cues and things like that, I mean, it can get administratively intensive to have to sit there and submit all of that. But again, I mean, for especially, for taxi people who, a lot of the money is coming from music on shows, that makes a difference, because otherwise, your music's on some show that's on like 28 reruns and you're not getting paid. So it's kind of one of those things, like, you're just leaving money on the table if you don't like take the step to register for a PRO.
What if they do it retroactively? What if they find out that for the last 6 months, my cue was on Catfish over and over. It's been played all over the world. And now I take care of my paperwork. Do I get paid in arrears?
Yeah. So the way that it works is, the PROs actually pay, because by the time the money actually flows through the whole chain of how the money flows through, it actually takes like 6 to 9 months to get to you, like from the time of the performance to when you receive the money. So usually if it's still like in the same accounting period, which is quarterly, that usually there's no loss of income because they can still track it within that same quarter. Now, if it's longer than that, I mean, again, as long as it's in a period that they can track it, it should be okay. But if we're talking like, oh, I wrote that 5 years ago and I never registered it, like, then you're going to have a problem, because the PROs, they can only go back for a certain period of time. And so at that point, like, you will end up losing money. And I get people all the time. I don't know why this is it's like this is such a phenomenon. But I get people calling me all the time. I wrote this song in 1978 and I have not been receiving my royalties. Why are you now in 2020 like just getting around to like looking after trying to get some royalties from
I know the answer
1978?
because
Okay, what is
I
it?
just quit smoking weed 6 months ago. I was stoned for the last 40 years. That's why.
Maybe, I don't know, but I mean, no, literally I get people leaving messages at my office all the time or emailing me. I've 20, 30 whatever years ago. I mean, there was one example where, and I can't say what the song was because it was a matter that I worked on, but it was a really famous song from the 50s. And the writer, one of the writers, was never registered with a performance rights organization. I mean, until like last year. It's like literally, I think millions and millions of dollars were probably lost. Yeah, because it was a really famous song. So, and it's just like, I mean, I think people think like, oh, people that are really famous, they've got it all together and everything's done correctly. Except like this stuff happens all the time. Whether you're just starting out or whether you're super famous, I deal with the same issues a lot of the time. And I mean, this is why I talk about this stuff. This is why I wrote the book, because, I'm seeing like nip this in the bud now, like do it right now. And then you won't have to call me in 30 years going, I didn't receive my royalties.
So what happens if the money is not collected, but technically it's been generated, it's just not been accounted for because they don't know this person exists to account for and send the money to? Where does the money go?
It goes in what we call the black box.
That doesn't sound good.
No, it's not good because you won't get it. Basically, and this is like all collection companies have this black box, not just PROs. But it goes in this black box, and then if it's not claimed, then after a certain period of time, it gets distributed. But it gets distributed based on market share, which means we don't know whose money this is, but these like 5 companies earn the most in our industry because they have the most songs. So it's probably theirs and we'll distribute to them. So if you're an independent writer and you're not registered properly and your money goes in the black box, it's going to one of the major publishers because if you can't claim it. So somebody else is getting paid for your music, which also happens a lot if the registrations are not correct. Like, because I had an issue once where somebody else had done the registration. I think a publisher had done the registration. I've had this happen twice. And they registered, like my client in both of these cases had like the same name as somebody else because they had like fairly common names. And it got registered with the other person that had the name and not my client that had that name. And then I had to like call and get it fixed and I got it corrected and all that. But I mean, for a while there was like, especially one of them, because again, it was an older song and he just like had no idea. And like somebody else was like getting paid for years on his song. And I was like, So, yeah,
It's
I mean, you
heartbreaking.
gotta, even if you're not the one doing the registration, like if you have a team member, if you like are signed with a publisher or a library, you still need to kind of have an eye on it and like go on, because the repertoire databases on BMI and ASCAP, those are open to the public. You can just go online and look at them. So you can go and look if it looks right or not, or you can see like, hey, that's not me. So, and then, call up the company and be like, this is not registered right because that writer that's on there is not my account. So you still have to like keep an eye on it, unfortunately, which is like why, you know, why, like, the point is that, creators should be creating and there's other people to handle these other things. But, at the end of the day, like, you're the one that's not getting paid if it's somebody else's mistake. So,
Yeah,
you know,
being a musician is being a small business.
it
And I know
is
from my experience,
100%.
you're a small business, I'm a small business. You don't just get to sit down and write contracts. I don't get to sit down and just come up with cool ideas for fun stuff to do with taxi members. There's
Yeah.
all this other stuff that goes on in the background to make sure
Hmm.
that,
To run the business.
yeah, that
Yeah.
you're paying the right taxes so you don't end up with a huge tax bill and all kinds of penalties, that you're, yeah, just all that stuff. There's a lot of responsibility that goes into being a grown up.
Yeah. This is true. Adulting.
Yes.
All right, so I just want to quickly mention a couple other collection services, and then I'll talk a little bit about contracts because those are important, and then that way we'll have some time for questions. So another collection service is called the Harry Fox Agency. They collect mechanical royalties, which is basically the royalties to the publisher slash songwriter from the record label or the streaming service for the reproduction of that composition on the medium. So whether that's a CD, a vinyl, a digital download, or a stream. So there's the compositions being reproduced in all those formats. So there's this royalty called the mechanical royalty that gets paid for that. And again, if you're not signed with a company and you're your own publisher, it makes sense to sign up with the Harry Fox Agency. It's actually free to sign up with them. So that way, at least, like, somebody is collecting these on your behalf. And then the other one is Sound Exchange. And Sound Exchange is sort of the sister to the performance rights organizations that we just talked about. But Sound Exchange collects on the master recording. So master recordings are able to earn performance royalties for digital performances. So that would be satellite radio and also streaming. And so Sound Exchange will collect those performance royalties. And it's also free to register on their website. And again, with Harry Fox and Sound Exchange, you still have to submit like record of your work. So they have spreadsheets and stuff that or individual registration kind of little forms on their website that you'll have to submit. But it's, again, at least you're having somebody collecting those, so they're not just like disappearing into the ether or being paid to, some major company that, that has nothing to do with you and is not going to be sending you a cut of it. So, okay. So then, quick word on contracts. So there are some agreements that are most needed by independent musicians because it's kind of the same scenarios repeatedly based on the types of working relationships that independent musicians have. So the first one is called a songwriter split agreement, and that is basically, and that's if you're co-writing with anybody, you have to have this. Because it will create a lot of problems if you don't, and I'll explain why. But what a songwriter split agreement is it's a short agreement that lists the title of the song, who composed it, what everybody's shares are, whether everybody is managing their own shares, we call it administering, or if, like maybe one person out of the group is doing it on behalf of everyone. So it depends on the situation and who the co-writers are. But it's so important to have an agreement like this because there always ends up being disputes on the splits later. And especially now, because it used to be like, there was only like 2 or 3 writers on a song. Now there's like 9 in a lot of cases. So, and you've got that person with the 2% or the 5% that's like thinking they should have more. So, and one example of like an issue where this happened, where there was this band that was in the studio, and so it was their first album. They had just gotten signed. They were in the studio. They were writing songs in the studio and recording. And, it was very exciting because it was their first album. So they had, friends in the studio and girlfriends in the studio and, pizza and probably drugs and, who knows. So we don't know about that. Anyway, like one of these songs ended up becoming a hit, and, the money starts rolling in and the band starts getting famous. And then this woman who was a girlfriend of one of the band members at that time when it was recorded, who's now an ex-girlfriend because these things happen, she called the band and was like, well, that's great that this song's doing so well, but, you said that I was going to get 10% because I suggested that line, the blah, blah, blah line. And whatever it was, I don't know.
I love that song.
Yeah, isn't that a great one? And so they were like, no, like, what are you talking about? We never said that you got a percentage of the song. And she said, you said that I get 10%, and if you don't give it to me, I'm hiring a lawyer. And so she hired a lawyer, and the band had a choice. There was no songwriter split agreement. There was no paperwork as to like who had what percent or who wrote what percent. And so the band had a choice of either giving her the 10% or, getting into a lawsuit with this woman over whether she was owed the 10%. And she had no proof that she actually wrote that line or suggested that line. The band had no proof that she did not. So, I mean, it really could have gone either way because it's, just he said, she said. And when you get into a litigation like that, a copyright infringement litigation, it's very expensive. And so the band ultimately decided to just give her the 10% because it was much cheaper and much easier than having to fight it when they didn't have any proof. Now, if they would have had a songwriter split agreement, they could have produced that piece of paper and said, look, we wrote the song on this day. These are the writers. Everybody signed it. Your name's not on here. If you were a writer, it would have been on there. And that, would have seriously helped them in any sort of lawsuit or anything like that. But because they didn't have that, they just had to give the 10%, which is really unfortunate because if the woman really did not write that song or that line and was just trying to kind of capitalize on it, that's really unfair to the people that did write that song. So don't be in that situation. And I mean, really, again, it happens all the time. And the songs get put on hold and the royalties get put on hold and, it becomes a big issue, and it happens on famous songs too. So it's not only independent musicians or songwriters, but, don't have that happen to you. And it's, people say, when is the best time to sign it? And the best time to sign it is actually when you write the song, because then it's, fresh in everyone's mind as to, who wrote what. And, I would say, because people don't want to present it because they don't want to kind of kill the creative vibe. But it's for everybody's protection, not only your own protection. I mean, the other person should appreciate it because it's for their protection too. But, it's better to do that than end up in a split dispute and then either the song's not released or you can't get paid. And some of these things go on for years and years. I mean, there's things that I've dealt with where songs have been locked up for years, and the company just like sits there holding the money and not paying it to anybody because they don't know who to pay, because they're not going to just pay it out arbitrarily. Like, they need something in writing showing who to pay. So that it's a problem. Michael, I have more agreements, but I see that we only have 15 minutes left.
I've
So,
I've got quite a few questions I've been saving up
okay.
for you if you want to do those.
I'm fine with, yeah, I mean, we can go into questions because I know people really like that opportunity. And,
I
you
don't want to
know,
deprive you of valuable airtime, so I'm going to suggest an alternative. I can go either way in this. I don't have a preference, but we could have people post questions in the comment area once the video's up on YouTube, which will be shortly, and you could go in there and answer them. Or,
I'd rather just answer them now, to be honest. And
okay.
then, not to like, keep plugging the book, but like I do talk about all of this in the book, so that's like another alternative, and I talk about it in more detail than we have time to do today. So,
And a lot of this
so
stuff
that's
we've
an
covered as
option.
well on previous visits on
Yeah,
Taxi
yeah.
TV. So there's no shortage
So,
of Erin giving
yeah.
out great advice, entertainment
So,
purposes only.
yeah, let's do some
Whoops.
questions.
All right.
That's right.
First one I got
So let's
was,
do some questions, Michael.
if something is written as a work for hire, does the composer still get the performance royalties?
Usually, but I mean, it definitely depends on what the terms of the agreement are, because sometimes the work for hire will be just a complete buyout of everything. But I would say it's most common that the composer will get the writer's share, because the performance rights organization pays the writer's share directly to the writer. It doesn't go through a publisher or other third party company. So again, typically that's what happens, but you do need to understand whatever the terms are of the particular work for hire situation that um, that you're in. So if you don't understand it, seek advice.
Absolutely. Next question. What if you register and a publisher retitles your song under a new name? So if I write, Michael had a little cow, and then I do it. Hey, what can I say? I grew up in a farm community. Okay, Michael had a little cow. It was so cute, and then I sign a deal with a music library, music licensing company, whatever form of publisher, and they retitle it because we've done a non-exclusive deal, and they want to retitle
Yeah.
it. Their retitle might just be like ABC Library dash
Right.
Michael had a little cow, or it could
Right.
be the little cow is Michael's pet.
Right.
So, what happens when a publisher retitles it to your original registration?
Yeah, it's a problem. So, and here's why it's a problem. So, a lot of times when they're tracking performances, the PROs use like artificial listening kind of technology, or like I don't know exactly what it's called, but basically
Yeah, audio fingerprinting,
yeah,
watermarking stuff.
exactly.
Yeah.
So, so what happens is it'll register, a performance, but because, Michael had a little cow and ABC Library and Michael had a little cow, or Michael had a cow that was a pet, are all the same song sonically, it will like show all those as matches, and then the PRO will be like, well, which one do we pay? So what ends up happening is, if this is a situation where it's like a performance on television, they have to rely on the cue sheet as to which actual version it is. So that way they know which one to pay. But if there's not a cue sheet, then it creates problems. And they often don't know which one to pay, which is why, and I've talked about this before with taxi members in my previous classes, and I think we've probably talked about it on Taxi TV before. I mean, this is why retitling is a problem, because it makes it confusing, and it makes it more problematic to get paid, because there's these discrepancies in the data.
You would think that they would use audio fingerprinting technology to embed, a subsonic ID within the song, so that every library could have one in there. The technology exists. Why they don't use it, I do not know.
I don't know. Why a lot of things happen, we don't know.
That's for sure. What if? Okay. Do we need to copyright before submitting to Taxi?
So I mean, obviously it's an individual choice. I always recommend yes. But because here's the thing, if you haven't registered for copyright, you need to keep track of who has that. Because if it's an infringement suit, if like there's an infringement later, you have to prove that whoever did the infringing, supposedly, had access to your song. So like if, the only people that have heard the song are like your parents, and then all of a sudden you're like, that new Beyonce song sounds just like mine. Like probably they're not going to find any infringement because they're going to be like, well, how did Beyonce like hear your song? But if there's a situation that would be like more applicable to taxi members would be like, you're submitting songs to different libraries and maybe you don't hear back from a library or whatever, and then all of a sudden you hear either your song exactly or maybe a very similar song in a show that the library provided music for. So that could prove the access part of it. So I'm a lawyer, so I always recommend doing the copyright first. So it's there, it's protected, you have that data creation, you don't have to rush an application like we talked about earlier. But obviously, it's an individual choice as to whether someone does that. But if, in either case, still keep track of like who's getting copies of your music.
I want to point out a scenario that I'm sure is relevant for a lot of our members because at least half of them do instrumental cues. So an instrumental cue, it would be an extreme unlikelihood that an instrumental cue is going to ever generate significant dollars. The business model for instrumental cues, get a lot of cues out there in a lot of places, and they each make a little bit of money. It's something earning what I Will Always Love You did as a hit record or the theme to Titanic. Not going to happen with an instrumental cue. Probably going to generate in aggregate over several placements under $100 a year. So most of our members who submit instrumental cues to libraries don't bother registering them. First of all, they don't register the copyright because then it creates opens up a whole other can of worms when the library that signs it, and they may want to register the copyright. And truthfully, because many of the members in libraries know that the amount of money that a particular cue will earn is just not worth going to court over. Just simply sending a letter from an attorney to the other party would cost more than that cue would probably earn. So I'm not giving legal advice. I'm not even giving my own personal opinion here. I'm just saying that people who write songs, if you've written a song that Dolly Parton could cut or Beyonce could cut, somebody big could cut and have a hit with it, you should absolutely register that copyright because that's a different level of income and business. But for a cue that may earn no money or earn under $100 a year, that's a choice you have to make. I'm just telling you what I know from experience that a lot of taxi members do.
And I know that a lot of people take that perspective. What I would say to that is, so if you've already registered the copyright and you're assigning it to a library, you can always assign that copyright to the library. So that really shouldn't be, a preventative from registering unless, again, you just don't want to pay the costs. Right. But the other thing is if you're somebody that's building a library, you actually do want them registered because if you ever want to sell that like as a collection and sell the catalog, whoever's buying that will want chain of title documentation to make sure there's no problems with ownership. And if you've never registered those copyrights, then there's no chain of title. And it becomes a bad investment potentially for a buyer, and it becomes unattractive for a buyer because they're not, it's like if you went to buy a house and the person was like, sure, I'll sell you this house, but I don't have like any, proof of ownership of it. So
I squatted, like, therefore you can buy it from me.
Yeah, like, so maybe I have, some squatter's rights, but I don't, you can figure it out later, but sure, I'll sell it to you. So, I mean, it's not quite the same because, I mean, you generally know who wrote, if it's all your own compositions. But again, like a third party buyer is going to need that documentation, because if they, let's say they buy your catalog, and then somebody else comes along and says like, well, I was a co-writer on this, or, I had this ownership, or they sold it to me 6 months ago, or, whatever it is, that creates then like significant legal problems for the buyer. And I've had this happen with catalogs, that people did not do the proper due diligence up front, and then they end up, having to fix a bunch of problems after they've already bought it. So, next question.
Yeah, I'm receiving royalties. Oh, you're going to love this one. It's our our favorite topic.
Favorite topic.
Yeah, I'm receiving royalties from CD Baby. Does that jeopardize taxi submissions? And I would add to that, does that jeopardize submissions anywhere?
Right. Well, that depends on whether you're receiving publishing royalties, or it's just the distribution money from sales or streaming of your recording. So if you're just signed up with any of these distributors, if you're just signed up with the distribution part of it, which is like the getting your album into iTunes and Amazon and all that, then no, it shouldn't be a problem. If you have signed up for any sort of publishing package or collection, or let us collect these other royalties for you.
Would you like us to monetize your music? Check.
Yes. Yeah. That then becomes a problem, because if you're signing up for the publishing part of it, that company is then your publisher, and they also are the company that has the right to pitch your music or license your music for sync. So in that case, you would have a problem with signing taxi deals.
And we see that all the time, literally already just this week alone, because we played music yesterday with, we did a listening session with Michael Lloyd. And
you got blocked.
Well, we didn't get blocked, but what we got was, sorry, you can't monetize this. Not that we really care. We might have made $4.62. Right. The point being that, library owners call me and say, I can't believe this. I just went through all my due diligence, and the last thing I checked was, did this person have a deal with publishing or an admin deal with CD Baby or whomever? Not saying anything bad about CD Baby, but they forget they sign them. They don't understand what they've signed, which is why they should buy your book. And now they can't do a deal with any library unless they make that other deal go away, which sometimes you can, sometimes you can't.
Right. And I've seen that happen where there was, this happens, this has even happened at like a larger scale too, where the artist went on, or the writer went on to sign a deal with a pretty large publishing company. And then it was like, all of a sudden there were two deals, because they didn't realize that they had already had this other deal with this distribution company for the publishing. So then literally these two companies were like fighting over who got to claim the music, and the writer was in the middle, and it was a really big mess. So don't do that.
I just had a follow-up show up in the chat, which says, can't we just say CD Baby is the publisher when we need to?
No. You're either in or you're out.
Right. It's like, I'm married to my wife when it's convenient.
Right. Yeah,
but when I'm on the road, not so much. No, it doesn't work like that. All right. We've got time, I think, for one more. Let me go up here because I saw one. Is the digital ID sufficient? Example, Pro Tools, Logic Pro, etc. provide the creation dates, of a particular track. Would that be sufficient enough for a copyright disagreement?
No. So again, the only thing that a court is going to look at is the date on that federal registration. Now, whether they might look at other evidence if there was a case, maybe, but the strongest evidence that they will consider is what's on that federal registration. So while it's definitely a good idea for you to have your metadata embedded, because metadata is very important, for many reasons, payment being one of them and ownership being another one of them, just for tracking purposes, a court's not going to be like, oh yeah, so you had it embedded in the Pro Tools file, so it must be yours. They're going to look at the federal registration. So
Okay, I'm going to do one more, which is a follow up on something else, and then we'll wrap this up. It did go by way too quick.
It way too fast. There's like so much more I wanted to talk about.
I know. So, Michael, are
Follow
you
up.
saying that unless there is a deal imminent with someone who's going to make your song a hit, it's not worth getting it copyrighted? No, I didn't say
No,
that.
nobody
you,
said that.
I was saying that many of our taxi members don't bother copywriting what I affectionately call stupid little instrumental cues because they know that there's never going to be enough money. The likelihood of them generating enough money during the lifetime of that cue is less income than you're going to make, or than it's going to cost you to copyright it or litigate it or blah, blah, blah.
Right.
However, a song, if I wrote a song that I think is a hit and I'm going to sign it to a publisher who's going to run it all over the industry, to various labels and artists and producers, you bet your butt that should be copyrighted because it's out there in the wind. It could easily be skanked by somebody, for lack of a more professional word, and you want to have that copyright registered so that you can prove that it's yours. It's a different ball game, a different dollar amount than a cue.
And sometimes cues go on to bigger things too. So you never
It's
know.
true. Yeah, that's a good point. You could write a cue, let's say, for a trailer. And the trailer, well, of course, that's going to play, well, in the old days before COVID, the trailer would play
Yeah.
mostly theatrically, which doesn't pay in the US, does pretty much everywhere else
No,
in the
but you
world.
would still get a nice sync fee because trailers pay higher sync fees than just, regular episodic TV. So,
Yeah. Well, this has been fun. Shorter than I would have liked, but I will have you
yeah.
back, I promise. And now that I've got my personal handle on the technology that brings a second person in on Wirecast and feel pretty comfortable with it, I will reach out to you relatively soon and have you
Okay.
back.
Yeah.
And let's not forget about the book. I'm very happy that you wrote that book because, you can learn so much from books. And all these questions that people are asking in the chat, I'm sure will be answered in the book. And so what's the book going to cost? Do you know the retail price yet?
So the ebook is $9.99 and the print book is $14.99. And if you sign up for the pre-order, like I said, you get the ultimate royalty chart and the catalog spreadsheet template as free bonuses for committing to the pre-order. And yeah, I mean, I mean, I know I wrote the book, but I mean, there's really a lot of information in there that would, cost thousands of dollars to have someone teach it all to you. And I just really felt like there needed to be like that primer book that people could really like rely on as a handbook, because so many of the books out there like already assume that you know a whole bunch of stuff and it's like on another level. And this is really like the straight to the point, what you need to know. Like I said, like handbook that you can just keep with you and reference whenever you need it. And it just breaks it down in plain English.
Why wouldn't you spend the equivalent of 2 or 3 cups of coffee at
Yeah,
Starbucks to have a book?
exactly.
I mean, just to give you guys some perspective, the minute you reach out to an attorney and say, somebody has infringed my song, and the attorney goes, I've got to say, there may be a case here. That first look at your case and the letter, the poison pen letter, as I call them, that's going to go out to the offending person and their attorney, that's going to be somewhere between $2,500 and $5,000 right there, and we haven't even really officially started a lawsuit. Is that a true statement?
Yeah, I mean, I would say if it's a very simple letter, I mean, I don't know of anybody that would write a letter for less than $1,000. But in a case like that, I mean, yeah, they have to like lay out all the proof of why it's an infringement. So yeah, I would say that that's an accurate estimate of like $2,500 to $5,000 for just the initial letter. I mean, you're looking at a 5-figure retainer just to get going with the case.
Wow.
So, again, like having the little book that just like tells you all this, like how to collect your royalties, why you should register for copyright, what agreements you need, why you need them, like, all these things, because people there's a lot of misinformation out there, and I get asked the same questions a lot. So that's what I tried to address, as to like, here's what you need to know to understand these. I go through like a whole explanation of what every royalty stream is and how it applies, and when it's earned and how you collect it, and so it really breaks it down.
Well, this has been great. I have to
yes, thank you, Michael.
Go get ready for my next thing. Thank you. Thanks for sharing this stuff. I hope people buy the book, because it just makes so much more sense to spend $10 for the digital or $15 for the hard copy now. You're going to save yourself so much money, and you won't get screwed, damn it.
Right.
All right. With that, I'm going to say goodbye. Bye, Erin. Great to see you.
Bye, Michael. Bye, everyone in the chat.
See you guys in the chat. All right. Take care. Bye-bye.
You too. Bye.